Democrats are fighting back by holding shadow hearings where they're calling whistleblowers before these hearings that the MAGA Republicans are too cowardly to hold. And these Democrats from the Senate and the House of Representatives exposing the Trump regime corruption. I think the MAGA Republicans want to still focus on Hunter Biden and former President Biden. And the Democrats are saying, can we talk about the hostile federal government takeover by Trump and Elon Musk? If you don't want to hold hearings, we're going to hold hearings. By the way, we here at the Meidas Touch Network are broadcasting these shadow hearings. They're getting huge viewership as we are streaming them here on the YouTube channel Meidas Touch. Make sure you subscribe, by the way, so you stay up to date on all the shadow hearings. And so, yes, the Meidas Touch Network is the main destination for covering all of the protests and the shadow hearings. It's an honor that we're able to build this platform to do that. The shadow hearings yesterday were incredibly powerful. You had Democrats in the Senate led by Senator Adam Schiff, Democrats in the House led by Jamie Raskin, holding this hearing based on the Trump regime's attack on the DOJ, attack on law firms, attack on colleges. One of the key witnesses to show up was somebody by the name of Liz Oyer. She worked in the Justice Department, and about last month we learned her story that she was fired after the Trump regime demanded that she basically look into and issue a formal recommendation to kind of pardon Mel Gibson, which would then restore Mel Gibson's right to kind of get back a firearm because of Mel Gibson's past. That she analyzed it as Liz Oyer, who is in the pardon division of the Justice Department, said, based on a past of potential domestic abuse and other conduct, we can't pardon this guy. We can't give him a gun back. I'm not going to be involved in doing any of that. And she said, no, I'm not going to do it. She shows up basically the next day to office at the DOJ. She gets fired, and then she gets threatened, intimidated, and harassed, she says, by the Trump regime DOJ, including Todd Blanche, she says. And she said she got this letter saying that she was breaching her ethical obligations and that she's, that they could, potentially do other stuff to her if she continues, down a path of violating her ethics, with a clear insinuation that like her bar license could be on the line and her ability to be a lawyer. So clearly threatening and intimidating her. So she was one of the star witnesses at this shadow hearing. And get this, before showing up at the hearing yesterday, again, which was broadcast live here on the Meidas Touch Network, she says at the end of last week, when it became known that she was going to be testifying, the Trump regime through the U.S. Marshals were sending her correspondence and letters that they were prepared to send armed U.S. Marshals to her home to try to intimidate her into not testifying before the hearing that took place yesterday. So that's right. According to her, the Trump regime sending armed U.S. Marshals to her home, or threatening to do that. They finally ultimately didn't do that, but they threatened that they would send armed U.S. Marshals to serve her with a letter saying that if she testified, that they would go after her for violations of executive privilege, bogus allegation, that they would go after her for violations of the ethical obligations that she owes her client. It should be noted, I want to show you her testimony that we covered here on the Meidas Touch Network, where she talks about this, but it should also be noted, the story of Abrego Garcia, who was sent to the El Salvador concentration camp, even though there was an order, by the way, from a Trump immigration judge back in 2019, that he was not to go to El Salvador. He was here on protected status. And ultimately, the United States Supreme Court basically stayed or stopped the Fourth Circuit Court of Appeal order and the District Court order, which required Trump to bring Abrego back within 24 hours. That order from the district court and the Fourth Circuit's been indefinitely or permanently stayed for now, pending the proceedings before the United States Supreme Court. But the Department of Justice lawyer who argued for the DOJ and admitted that there were mistakes and errors that were made that shouldn't have taken place that led to Abrego going to El Salvador, they ended up putting him on administrative leave and punishing him for telling the truth to a district court judge, as was his duty of candor owed to the court. And of course, we've seen this repeated attack on DOJ lawyers. The DOJ lawyers who refused to dismiss the case initially against Mayor Eric Adams, terminations of FBI officials. Anyway, this was these issues were being discussed at this shadow hearing, which the MAGA Republicans refused to cover. So let me show you right here Liz Oyer's testimony first at the shadow hearing yesterday. Let's play this clip.
Perhaps the most personally upsetting part of the story is the lengths to which the leadership of the department has gone to prevent me from testifying here today. On Friday night, around 9:15, I learned that the Deputy Attorney General's office had directed the Department's Security and Emergency Planning Service to send 2 armed Special Deputy U.S. Marshals to my home to serve me with a letter. The letter was to be served at my home between 9 o'clock and 10 o'clock on Friday night. I was in the car with my husband and my parents, who are sitting behind me today, when I got the news that the officers were on their way to my house, where my teenage child was home alone. Fortunately, due to the grace of a very decent person who understood how upsetting this would be to my family, I was able to confirm receipt of the letter to an email address, and the deputies were called off. The letter had been emailed to me just before 8 o'clock that night. At no point did Mr. Blanche's staff pick up the phone and call me before they sent armed deputies to my home. The letter was a warning to me about the risks of testifying here today. But I am here because I will not be bullied into concealing the ongoing corruption and abuse of power at the Department of Justice. DOJ is entrusted with keeping us safe, upholding the rule of law, and protecting our civil rights. It is not a personal favor bank for the president. Its career employees are not the president's personal debt collectors. I see only Democratic members here today, but this is not a partisan issue. It should alarm all Americans that the leadership of the Department of Justice appears to value political loyalty above the fair and responsible administration of justice. It should offend all Americans that our leaders are treating public servants with a lack of basic decency and humanity. Thank you.
Powerful stuff right there. And just to remind you too of, again, I described it at the beginning, the whole situation with Mel Gibson and how Trump wanted her to issue this pardon for Mel Gibson. Here's Liz Oyer describing it in her own words when she went on CNN a few weeks back, where she talked about her termination and how she was fired. It's important that you hear this story, and I'll give that first clip some context. Play this clip.
I was asked to write a memo to the Attorney General recommending that these 9 individuals get this relief that she was interested in granting to some deserving Americans. And when the memo came back to me, the comment was, please add Mel Gibson to this recommendation.
Who asked you to add Mel Gibson?
An official in the office of the Deputy Attorney General who is running this project on the day-to-day instructed me that Mel Gibson should be added to the memo.
Do you know the name of that person? Could you share it with us?
It's one of the associate deputy attorney generals. There are several in the office, and I don't want to call anyone out by name, but there is email traffic between me and a number of individuals in the deputy attorney general's office about this issue, and the request was made, and I responded that I was unable to fulfill the request because I did not have enough information about Mr. Gibson to be able to recommend that, given his history of domestic violence, he should receive his gun rights back. That's something that is a public safety question. It's very dangerous to mix people with history of domestic abuse and firearms. That substantially increases the likelihood of catastrophic outcomes in domestic violence situations, and that was just not a recommendation that I could make lightly.
So how long between when you sent that response saying you could not in good faith recommend Mel Gibson and the time you were fired?
It all unfolded very quickly. I was asked to add him to my recommendation on Thursday evening, and I did not sleep at all Thursday night because I understood that the consequence of not fulfilling this request was likely that I would no longer even be in these conversations. Dissent within the Department of Justice is just being aggressively silenced. People are afraid to speak up. They're afraid to object. I confided in a colleague who expressed the view that yes is really the only acceptable answer to requests that are being made by department leadership. And so I understood that the consequences were potentially serious for my career at the Department of Justice. And when I came into work on Friday morning, I said to a colleague, I really think that Mel Gibson might be my downfall. And within hours of saying that, I was being escorted out of my office.
And you got this letter from Todd, with Todd Blanche's signature on it saying that you were being terminated.
Yeah, I've never met Mr. Blanche, but I received that letter with his signature saying I was being terminated.
So we have a statement that we got from Todd Blanche, who is the Deputy Attorney General, for people who don't know. And in it they said, quote, "This former employee's version of events is false. Her decision to voice this erroneous accusation about her dismissal is in direct violation of her ethical duties as an attorney and is a shameful distraction from our own critical mission to prosecute violent crime, enforce our nation's immigration laws, and make America safe again." What is your response to Deputy Attorney General Todd Blanche?
Look, Caitlin, it's terrifying that the number 2 official in the Department of Justice believes that my ethical duty is to keep silent about what is going on inside the Department of Justice. My ethical duty as a DOJ employee is to uphold the laws of this country, to do justice, and to serve the people who I was appointed to serve. It is not to hide the fact that career employees like myself are being punished for expressing dissenting views and for refusing to follow direction.
And again, this was all being streamed, the shadow hearing, on the Meidas Touch network, the official destination for shadow hearings. We're going to make sure we're covering all of these hearings. This is Democratic Senator Adam Schiff. These are his remarks from the shadow hearing. You're going to want to watch this whole thing. This is very, very powerful stuff, as exclusively seen on the Meidas Touch network yesterday. Let's play it.
And we've come to realize, much to our shock, that there's nothing inevitable about this. There's nothing inevitable about democracy or democratization, that this experiment in this country, this great experiment, self-governance, now 2.5 centuries old, is not inevitable. It was improbable at its start. And we've witnessed something we never would have imagined in this country. We have witnessed with incredible rapidity the creation of a climate of fear by this administration. We see universities afraid to speak out, to defend their own students, to defend their own academic freedom. You see universities rushing to make deals with the administration. You see universities cowed into silence, not stepping up to defend other universities. You see members of the press excluded from public events because they don't use the administration's favored parlance. And you don't see other members of the press in solidarity with them. You see law firms rush to cut separate deals. You see lawyers purged from the Department of Justice. You see FBI agents purged from the Bureau. You see scientists purged from their agencies. A wholesale effort to weed out and drive out anyone of independent thinking, anyone who will stand up and defend the rule of law or science or the freedom of thought or expression, right down to ordinary citizens who are now afraid. If the government of the United States can pluck a man off the street and send him to a prison in El Salvador without any kind of due process or any process whatsoever, then no one is safe. And if the government's response to that is to discipline a lawyer who dares to speak the truth to a court, then no one is safe. And the answer to this climate of fear, there really is only one answer, and you're seeing it today, and that is courage. We must demonstrate courage in the face of this fear. In this very committee room, or one like it, Joseph McCarthy and his allies made the country afraid and caused people to inform on each other and betray each other, allowed people and to be driven out of the government and to be persecuted. And we wondered how that could be. We wondered how could so many people be complicit. Well, now we know. Now we know. Now we have witnessed it in our own time. But I will say this of the brave witnesses who have come and testified today. All of the rest of us have to ask ourselves, looking back at the McCarthy era, what would we have done? What would we have done if we were faced with the loss of our jobs, if we were faced with the loss of our livelihood, if we were faced with the loss of our position? What would we have done? Well, you don't have to ask that question. Your being here is all the answer anyone could demand, and we are deeply, deeply grateful to you.
Now, before the hearing, as Senator Schiff noted, as I noted at the beginning of this video, the Trump administration is trying to intimidate and silence Liz Oyer, a Justice Department attorney who was fired for doing her job. Today, we'll be hearing her story. So this is from her law firm, the Bromwich Group. Here's what they say went down. They said to Todd Blanche, who, by the way, was Donald Trump's personal attorney, who Trump appointed to one of the top positions at the Department of Justice. Dear Mr. Blanche, we represent Elizabeth Oyer, the former pardon attorney for the Justice Department, who was wrongfully fired on March 7, 2025. I am writing specifically with reference to the April 4, 2025 letter she received from Miss Kendra Wharton of your office. Miss Oyer became aware late Friday evening that your office had directed the department's security and emergency planning staff to have 2 armed special deputy U.S. Marshals personally serve her with a letter at her home that night. Armed U.S. Marshals. The deputy marshals were directed to serve the letter between 9 p.m. and 10 p.m. when Miss Oyer's teenage child was home alone. Fortunately, while the armed officers were en route to Miss Oyer's home, she was able to confirm receipt of the letter, which had been sent to a secondary personal email address at 5:58 p.m. and forestall the hand delivery by the deputy marshal at her home. Had your office simply contacted Miss Oyer by telephone or via the email address that Miss Oyer had used to repeatedly communicate with the Department Justice Management Division, this deplorable incident could have been avoided entirely. Not to mention the waste of government resources involved in using deputy U.S. Marshals, by the way, and armed ones at that, to accomplish the delivery of the letter at a time when the administration is ostensibly committed to ferreting out waste, fraud, and abuse. The highly unusual step of directing law enforcement officers to the home of a former Department of Justice employee who has engaged in no misconduct, let alone criminal conduct, simply to deliver a letter is both unprecedented and completely inappropriate. You appear to be using the department's security resources to intimidate a former employee who is engaged in statutorily protected whistleblower conduct. An act that implicates criminal and civil statutes, as well as department policy and your ethical obligations as a member of the state bar. As to the April 4th letter, it addresses Miss Oyer's scheduled appearance at a hearing on April 7, 2025. Miss Oyer was invited by members of Congress to testify about the circumstances of her unlawful termination from the DOJ when she served as a pardon attorney. a non-political position in the career senior executive service. Ms. Oyer has appealed her termination based on the lack of statutorily required process afforded to her and DOJ's disregard of whistleblower protections, among other issues. The April 4th letter from one of your subordinates warns Ms. Oyer about the purported risks of testifying at a congressional hearing. At no point does the letter advise Ms. Oyer of the legal protections in place for whistleblowers, which protect current and former federal employees reporting violations of laws, rules, or regulations, gross mismanagement or waste of funds, abuse of authority, or substantial danger to health or safety. Nor does your letter contain the limiting language that is statutorily required when the department purports to prohibit disclosures by a whistleblower such as Ms. Oyer. On the contrary, your letter and an attempted manner of delivery appear calculated to deter Ms. Oyer from providing truthful testimony as a whistleblower in further violation of these legal protections. Your tactics also appear to violate the Lloyd-La Follette Act, which provides that the right of employees to petition Congress or a member of Congress or to furnish information to either House of Congress or to a committee or member thereof may not be interfered with or denied. Executive branch employees are in fact required by federal regulations to disclose waste, fraud, and abuse to the corruption to federal authorities, which is precisely what Ms. Oyer seeks to do. As to the alleged legal basis for the attempt to intimidate Ms. Oyer from testifying that her testimony is barred by executive privilege, the argument is completely without merit. The president has not asserted executive privilege over any matter at issue here, nor have you identified specific information potentially subject to such privilege. Moreover, the executive privilege cannot be asserted to protect misconduct, as expressly noted in the OLC opinion cited in your letter. Mic drop right there. There you have it, folks. That's what's going on. More shadow hearings will take place. Of course, we'll keep covering them here on the Meidas Touch Network. It's why I want you to subscribe. We're showing you content here that corporate news and others are not showing you here. We're gathering in huge groups to watch these things together, to spread the knowledge, then, of course, to help organize the protests. Stay updated, everything here on the Meidas Touch Network by subscribing. Thank you for watching, and hit subscribe.
Can't get enough Meidas? Check out the Meidas Plus Substack for ad-free articles, reports, podcasts, daily recaps from Ron Filipkowski, and more. Sign up for free now at MeidasPlus.com.